How would I know if I have a bad faith case against my insurance company?
So you probably won't know on your own, which is why it's important that you find a good lawyer. The simplest way to know is if you feel alarmed by something that the insurance company has done in the claims handling aspect of your claim. That might be a good indication. So you should keep records of what transpired with your insurance company and get them over to an attorney to review. There are some telltale signs of bad faith. Delay is one of them, improper investigation, underpayment of your claim, and wrongful denial. So I can break down those for you with respect to delay. So say you contacted your insurance company, you filed a claim. They said, okay, fine. You don't hear from them at all. You contact them again. They've got no evidence that you even submitted this claim. And that you just feel like during this process, they keep kicking you down the can. They keep making it impossible for you to get your claim handled. That could be a sign of bad faith, particularly in long-term care cases. So if you have a long-term care insurance policy, one of the insurance company's kind of practices is delay. They make it as difficult as possible for you to get your claim resolved. And the intent is that hopefully the policyholder just gives up. Improper investigation is another one. So, you give information and documentation to your insurance company, and it's a long-term disability claim, and you have a letter from your doctor that says that you're disabled, that you can't return to your occupation, and the insurance company just ignores that. They cannot ignore critical documents related to your claim that would assist them in paying your claim. So that would be another reason that you should contact an attorney. Underpayment is another one that we see sometimes. So they'll agree to pay, but not what they should be paying. And then I guess the big one that everybody would naturally assume is a wrongful denial. So you submit a claim to your insurance company. You think that you should be receiving benefits sometime soon, and you get a letter in the mail that says your claim is denied. A wrongful denial could have a couple different components in it. One of them is like incorrect policy interpretation. So you have a policy. You should have a copy of your policy, a full copy, not just the statement of benefits. You want the entire copy of the policy. If you don't have that, you definitely want to reach out to your insurance company and get a full copy of the policy. You can ask them they might have to send it in the mail. Ask them if they can email it, and you should be aware of what the contents of your policy are. There are times in denial letters where they incorrectly interpret the policy. So they cite provisions that don't have anything to do with your claim, or they're misinterpreting how those provisions should be applied to your claim. That would all be part of a wrongful denial. Sometimes the denial letter it'll just miscite or mischaracterize key facts. So, maybe you had a telephone call with an adjuster and they did a summary of the telephone call in their notes, and they're saying that you said something that you didn't say, or they're mischaracterizing the context in which you said it. That would be ignoring key facts or using biased or misleading information to support their denial. Failing to communicate about the basis for their denial could also be an indication of bad faith. They are required to explain to you why your claim is being denied. If you're getting like a 2-sentence letter that says, yeah, your claim is denied, we don't think that you've got coverage, that's not going to cut it. So, and we handle all kinds of different cases, but in the long-term care context, say you're an adult child, your mom is 85 years old, and she has been diagnosed with Alzheimer's disease. And things have kind of gone south. She can't bathe on her own. There's a risk of her falling. She's fallen a couple times. Maybe she's not remembering that she's supposed to eat and she's not taking her medicine. She's, not capable of living on her own because it's a safety concern. And you find out that your mom's been paying a policy for 20 years. And this long-term care policy has provisions that would provide home health care assistance to have her stay in her home and have somebody come take care of her. Or perhaps she could go to an assisted living facility, and you call the insurance company and you say, I need to make a claim on my mom's behalf. They are going to say, okay, we're going to send you this claims packet. You got to fill out all this information. You've got to fill out an authorization. If you're going to be acting on your mother's behalf, we need a power of attorney. So you've got to start kind of collecting all these things and get them to the insurance company. You do that and they say, okay, well, we're going to send a nurse out. She's going to do a nurse assessment to determine whether your mom has 2 or more activities of daily living that she needs assistance with. So you say, okay, they send out this nurse. The nurse isn't necessarily an employee of the insurance company, but she's working on their behalf. So you are there during the process where the nurse is trying to figure out whether your mom needs assistance, whether that be standby assistance or actual physical assistance with these activities of daily living. But when she's doing that, she's supposed to be simulating whether your mom can shower or bathe on her own. And that wasn't done. Or, she's not completing the process for changing. So if your mom can't change her clothes on her own, and all the nurse has her do is put her hands above her head, but that's not the problem with your mom changing. You get the nurse assessment and you're like, that was a little weird, right? Like, I feel like it went okay. But then you hear back from the insurance company and the insurance company says, your mom's just fine. That, we got this nurse assessment and she can do all of her ADLs, activities of daily living, on her own. Your claim is denied. That's the time where you want to call an attorney.
So once we've decided to contact an attorney, what level of involvement should we have to expect moving forward throughout the process?
So I think a lot of times our clients, especially if you've never been involved in any type of lawsuit before, can be really confused about that. And I guess the lawyerly answer is it really depends. We do our best to gather all of the information that we can through the discovery process, which I'll talk about in a little bit. But there are certain aspects of your claim that we can't handle without you. So one thing we see sometimes is gathering information from the defendant, from the insurance company, can look like something different than gathering those same documents from the plaintiff. The insurance company keeps something that's called a claim file. It's supposed to have all of the information, correspondence, and documents about your claim in one place. And in 2024, it's electronic. They turn that over to us. But like I had been talking about before with delay, sometimes we see things differently from the plaintiff's perspective when they have their own notes or their own emails and communications that they've been sending to the insurance company. The insurance company's claim file doesn't always have everything in it that it should. And sometimes the plaintiff has documents or information or a log of telephone calls to prove that all of that stuff wasn't documented by the insurance company, that the plaintiff had sent over documents numerous times. We've seen cases where the plaintiff is trying to communicate with the insurance company and they are making telephone calls and they're like, can't I just email these documents? Then they say, okay, fine. We'll make an exception. You can email us the documents directly. And then they give them an email address that has a bounce back notification. Then the insurance company has the nerve to claim that the plaintiff is the one that's not submitting the documents when it's really the insurance company that's giving them bad information. So I'd say the more information and documentation that we can gather from you in the beginning of your claim, the better. Obviously, we know sometimes, if you're elderly and you're doing a lot of telephone calls, they're not recorded on your end, but we'll just do the best that we can through subpoenas and through getting documents from the insurance company to kind of fill in those gaps. One thing that we need to hear from you and that you need to be involved in is when you have a bad faith case and there's emotional distress damages, that comes from you. We can't tell you how you felt throughout this process. There's no other way of knowing than talking to you about it. So you can expect that you can be as involved in the process as you want to be. Some of our clients want to know everything. They want updates constantly. It's a really big part of their life. Other clients, they just don't have the time, the energy. They want us to handle most of it. And that's a conversation that you can have with us at the beginning of your case to sort of set the parameters. Of course, there are some things you must be involved with. And, you will have to sign discovery responses. You will likely have to have your deposition taken, and you'll probably have to participate. If it goes to mediation, you'll have to participate in that. And if you wind up at trial, you'll have to sit there unless there's some reason that we can excuse you from being there.
You mentioned the term bad faith, and I think it's sort of a great transition because we're talking about insurance companies and maybe there's an assumption that they operate in good faith or in your best interest as opposed to for profit. So can you talk to us about what bad faith is exactly?
So bad faith is the short version of the breach of the implied covenant of good faith and fair dealing, which is obviously a mouthful. So we just say bad faith. The insurance company has a duty to you as an insured to deal with you fairly and in good faith. When they breach that duty, we call it bad faith. It is improper for an insurance company to put its own interests ahead of its insureds. When it acts objectively unreasonable in the handling of your claim, they are violating their duties of good faith to you. And in California, that's actionable. I think the term bad faith gets thrown around a lot, and we see our clients say, well, it's bad faith, but it is something that has to be proven. It's a cause of action that we plead, and there are elements that you need to prove in order to get bad faith damages. And one of those things that you have to prove first is that the insurance company breached a contract. So you have a contract of insurance that you paid a premium for, and that contract, even though it was drafted by the insurance company, is binding between you and the insurance company. If the insurance company fails to pay your claim pursuant to the terms of the contract, then they've breached the contract. That allows or opens up the door to you getting bad faith or what we call extra contractual damages. So if the insurance company breaches the contract, they owe you for the amount that they should have paid under the contract. But in California, if you can get to bad faith and you can prove that the insurance company acted objectively unreasonable in the handling of your claim, then you can get what we call extra contractual damages. So that's damages above and beyond what they owe you under the contract. And one of the bases for recovery of that is emotional distress. And you can also recover your attorney's fees through extra contractual damages.
So the complaint is filed. What happens afterward? Do I participate in a discovery process?
So after we file the complaint, the other side has to answer it. Or they can file a motion to try to dismiss certain aspects of the complaint or the complaint in its entirety. So there's sort of this pleading process that has to end in the defendant filing an answer. Once that happens, the pleadings, we say they're closed. We move on to discovery. So discovery is kind of a legal term. It's the process by which both parties obtain and exchange information and documents about the case. So there are different components to that, but the main two that you'll probably be involved in are written discovery and depositions. So written discovery is just kind of like asking questions and answering questions. Those are called interrogatories. And then there's also requests for production of documents, which is where one party asks the other side, hey, give me all of these documents, give me the claim file, give me the communications, and the other side has to turn those over. We have to, as a plaintiff in the case, you have to participate in the written discovery process as well. Typically, the way that we work is we prepare discovery responses. So we answer the insurance company's questions to the best of our ability as lawyers working on your case. And we do that by gathering all the documents that we have on your claim, taking all the information that you provided to us previously, and sort of synthesizing that into responses to the questions that the insurance company is asking us. And once we gather that, we typically send it to you, or if it's, you could be the plaintiff on the case in a long-term care case, but your daughter or son is acting as your power of attorney. In that instance, we would send it to your son or daughter. They would have to take a look at the answers to the questions. And then they say, okay, this looks good, or actually, this is a little bit off. This isn't the right timeline. And we make revisions to those responses together. And then the plaintiff or their power of attorney has to sign what's called a verification. And it is a statement that says that the answers are correct to the best of their knowledge and ability. And I think something that our clients struggle with is that the written discovery process isn't just necessarily one set of questions and answers. There can be several rounds of it, and we do need your participation in making sure that those responses are accurate and getting documents for us that we have to turn over. So, we definitely will need some information from you, but we also try to, issue subpoenas to get records that we can obtain. And there's always going to be something that you can't necessarily get your hands on, and that's okay too. So, like I said earlier, the more information, the more records and documentation that you have about your claim, it helps us compare that to the claim file so we can get the whole story.
Nice. So the other side wants to depose me, and that can be a very nerve-wracking experience, or at least it sounds like it. What can I expect?
So your attorney should definitely talk to you about that process before your deposition date. And he or she should spend some time with you, letting you know what's going to happen. But it's not as nerve-wracking as a lot of people make it out to be. It's a process by which the attorney on the other side is going to ask you questions and you're going to answer them. In today's day, that could mean that you were sitting on Zoom and answering those questions in front of a computer screen, or sometimes we still handle them in person. So if you feel very nervous and you really want your lawyer to be right there next to you, sometimes that would be a situation where you're going to handle it in person. If you have a disability claim, I think a lot of times there's value to having the plaintiff sit down with the attorney from the other side. If you're living in a nursing facility and you're not leaving, then it'll be on Zoom and you might be asked a series of questions that could take anywhere up to 7 hours. But you have the right to take breaks. You can stop at any time. If you don't feel well during the process or you're feeling overwhelmed, you have the right to tell your attorney that you want a break or you want a break for the day and you need to come back a different time. So I think the nerves and the stress can sort of eat away at people's ability to answer the questions that are being asked of them. So, the pressure's not on the plaintiff so much. It's on the defendant. The plaintiff, you guys, you know what happened, you know your case, you know what's wrong with you, and you know what the insurance company did wrong. A lot of times, defense counsel is just using your deposition as a way to figure out what kind of plaintiff you're going to be at trial. If you're really evasive, or if you're rude and abrasive, if you can't answer a question because you're just dodging it or whatever, that's not looked at as favorably as if you make an honest mistake. So I think that one of the biggest mistakes that I see our clients making is they're trying to predict where the attorney is going with their line of questioning. So say, for example, the attorney says, well, isn't it true that you were outside walking your Yorkshire Terrier at 2 p.m. on this date? And in your head, you're like, what are they getting at? Are they saying that my claim isn't valid because I walked my dog? So the plaintiff is sort of wondering in their head, where are they going with this question? If you know that you walk your dog at 2 p.m. every day and they happen to catch you on surveillance, but every morning at 8 a.m., you need assistance getting out of bed because you just slept all night and that's the worst part of your day. But you kind of, you eat breakfast, you have some coffee, and later in the afternoon, you feel better. There's nothing wrong with just simply saying, yes, I was out there walking my dog. And by 2 p.m., if I feel okay, that's what I do. It's really first thing in the morning when I cannot get out of bed. I need somebody there or I'm going to get up and fall down or I'm stuck in bed. And I think that people get trapped thinking that they're trying to advocate for themselves by predicting where the questions are going to go. And you're better off just listening to the question that is asked and not worrying so much about where you think you're going with it. Us as attorneys, by the time we get to the deposition stage, there's a lot. Most of the information that is coming out of our client's mouth, we know already. And if there is something that we don't know, we can navigate around it. But what's most difficult is when our clients start saying things that aren't true. We take your case because we believe in you and we know that, you're going to tell the truth. And that's really all you're there to do.
So what should my expectations be in terms of the time commitment for this entire case, start to end?
I guess my first thought is that if you think that this is something that's going to happen within a couple weeks and that's all you're willing to commit to your involvement and to the resolution of your case, you're going to have to really consider whether you want to be involved in a bad faith lawsuit. There are a lot of factors that go into how long it takes, how quickly or slowly it takes for your case to resolve. And some of those are within our control and others are not. So, we can file a complaint as soon as possible. But we can't anticipate whether the other side's going to file a motion to dismiss. And if they do that they won't answer the complaint in 30 days. We have to file an opposition to that motion, and that takes time just for the pleadings to close. So something like that, depending on when you get a hearing, could take several months, and there could be several rounds of it. So, before you really even head into discovery, you have to make sure that you have a viable case with causes of action, and that does take some time sometimes. In other situations, you file the complaint, they file an answer in 30 days, and you're getting on the ball with discovery. As the attorneys, obviously, we can control how quickly we get discovery out, and we can hound the insurance company for answers. And I think the more that attorneys stay on the ball with that stuff, the faster we try to get through the written discovery process. We can set depositions and move the case forward that way. But again, if the other side refuses to give us certain documents and we really feel like we need those documents in order to take a deposition of a corporate designee or make sure that we have all of the notes from a claims adjuster, that can take time. We could have to go to court and file a motion to compel the other side to turn over certain information and documents. So I would say, a bad faith lawsuit, it's hard to get it resolved in less than a year. And sometimes it can be a couple years before they're resolved. And again, a lot of that is things that we can't control about the process, which, the courts in California and elsewhere are inundated. Their dockets are very full. So while we might be prepared to try a case in 3 to 6 months, if the court doesn't have any room for us on the calendar and we go to court to get a trial date, they might not be able to get us in for a year or a year and a half. And there's really nothing that we can do about the court schedule. The other thing is that is out of our control is the defendant's willingness to settle. Sometimes we have opposing counsel and they approach us as soon as we file a complaint and they say, hey, I think that we understand what's going on here and we'd really like to talk settlement early. We'd rather not rack up the costs litigating this case. Let's see if we can go to the table. Sometimes that works out. Sometimes it's feels like it's more of a fishing expedition. So there's a possibility that if you have a really good case and the insurance company doesn't want to pay, defense bills for a while, that they just say, hey, listen, you need to reach out to them and let's resolve this quickly. But we have other cases where the insurance company has no reason to settle. They are steadfast in their belief that they handled the claim appropriately, that they have a decent argument that they have, and they intend on filing a motion for summary judgment, which is a motion that either side can file, but it would, if they can prove that the case has no merit in the facts and law, then they can get the case dismissed, and then you don't have a case anymore. So sometimes if they feel very strongly about the case, they're going to litigate it to the point where they can file a motion for summary judgment, or sometimes they want to try it. I mean, usually insurance companies don't want to try cases, but it really depends on the facts and how they're applying the law. So if you don't have an insurance company that has a willingness to settle the case, that could definitely make your case take longer. So again, it's hard to set those expectations because there are so many factors that go into how long your case will take to resolve. But we do our best on our end in terms of pushing through discovery. And if it's in your best interest to try to reach a settlement, we do that. We do recognize that there is, the client has already been through a lot in this process. So we do our absolute best to make sure that we are litigating the case to its fullest capacity in a timeline that works for our client. And we understand that there have been many hurdles that the client has overcome just to get to where they are. So it is really important to us that we push the case along and reach a resolution as soon as possible.
The attorneys have now scheduled a mediation in my theoretical case here. What's going to happen? Explain the process to me.
Okay. So usually before the mediation happens, the parties come together and they decide on a mediator. So a mediator is usually, it could be a retired judge. It could be an attorney who's worked in this practice area for a long time, or an attorney who has general litigation experience where they've handled maybe construction cases and contract cases and insurance cases, and they kind of know how to do all of that stuff. So sometimes that process can take a little while because the attorneys will fight about which mediator they want to choose. But ultimately, they're trying to choose somebody who they think is going to do a good job understanding the facts and the law of your case, so that they can negotiate a settlement between the two parties. So if you're interested in knowing about your mediator, there are two large companies that handle mediations, JAMS and Judicate West, are out there. They have bios. So you can look up your mediator's biography. You can get an understanding of who that person is before you go in. Sometimes those things sort of settle your nerves about, it's a person and they practice law, or it's a retired judge, and you can find some, ability to relate to this person. And it kind of brings down the stress factor if you kind of know what you're getting into before you get there. But generally speaking, mediation is a fairly informal process. You don't have to go there feeling like you need to be in a suit and tie or that you're going to say the wrong thing. So before you even get there, you select the mediator, then the parties write briefs to the mediator. So it's basically like a summary and an argument of your case. So the plaintiffs write one, I would write one, and then the defense counsel is going to write a brief. We're both going to submit to them to the mediator about a week before the mediation's set to happen. And The mediator will read both of them. I would say more often than not, we submit our mediation briefs confidentially, meaning that we don't switch it, we don't switch sides. So the mediator reads our brief and defense counsel's brief in confidence. He doesn't exchange those two between the parties. There are instances though, and sometimes it is helpful for the parties to exchange their mediation briefs. I think that's particularly helpful when we're number crunching and we are trying to see a breakdown of how you're analyzing how you got to your number and how we got to ours. So it's kind of a case by case scenario of whether we're going to exchange the briefs or not. But then the mediator has a sense of the parties' arguments before the actual day happens. And then sometimes the mediator will have a call, like a private call with the attorneys to go over some things, or he'll have some questions about what you wrote in your brief, or can we get him some extra documents so he can take a look at those. That call happens before the day of. Then mediation, I would say at this point right now, it's probably about a 50-50 split, but it also depends on the case about whether your mediation is going to be in person. If the mediation is taking place in person, it'll likely be at either the mediator's office or maybe at one of the attorney's offices. And then if it's Zoom, you just show up, click on the link, and you're doing it from home. In bad faith cases, mediations are typically all day. And it can be kind of a long day. The mediator will come talk to maybe the plaintiff's side first and introduce himself, let you know how the day is going to work. But typically, the mediator is going from one room that has the plaintiff and their attorneys in it to another room that has the defendant in it. So it's usually defense counsel and somebody from the insurance company that has authority to settle the case. And what the mediator is trying to do is not convince, but to get information from both sides to reach a resolution that will resolve your case permanently. So a lot of the beginning of the day, just kind of typically speaking, will involve argument. So the mediator will come in, he's going to say, well, I don't think your case I think you've got a problem with this aspect of your case. And then your attorney's going to say, well, that's not really a problem to us because of XYZ. And then he's going to go to the defense side and they're going to say, well, we have a strong case because, the plaintiff did this. And sometimes that can be really difficult for the plaintiff to hear. And that's just everybody's job, though. Everybody's job as the attorneys is to advocate for their client. So even though you're hearing these arguments, sometimes they feel even more offensive. And you're like, I thought we were coming here to resolve this case. And now all you're doing is telling me that my case is bad. And we'll just rest assured that it's just part of the process. It's just part of posturing in order to get to the negotiations stage of the day. So at some point, the parties kind of just generally agree to disagree if they are really looking to resolve the case. Then the parties will start talking numbers. And when they start talking numbers, again, it's a negotiation. So both, the insurance company is trying to pay as little as it possibly can for your lawsuit. And you, by the time you've been sitting there and waiting for your case to resolve, probably want the most that you can. And sometimes it feels like a process where they're just trying to keep you there as long as you can to break you down. But I would definitely advise you to just try to take the process with a grain of salt. Know that if you're going into a long day, just bring a book or some form of quiet entertainment, and or you could work too. There will be downtime. If you're in person, they'll feed you. If you're on Zoom, you can, turn off your camera and walk around the house, and then your attorney will tell you, hey, it's time to come back in. The mediator's coming in.
And your point being not allow the stress of the day to bear, to cause you to maybe potentially take less just to be out of that awful week.
Right. Absolutely. So, don't let that process break you down and want you just throw up your hands in the air and give up. If anything, it's a good opportunity for you toward the end of the day to articulate how stressful and emotional this, the insurance company's bad faith has been for you. And, I think a lot of times our clients' emotional distress winds up coming in the form of anger by the time they're at mediation. And that's totally fair, right? They've been jerking you around since day one. You've been trying to resolve this claim. You've done everything that you can to give them documents, to communicate with them, and they still left you high and dry after you've been paying premiums for a long time. To me, I think anger is a totally justified emotion, and it is stressful. So if I could just give you one point of advice, just don't use the mediation process to exhaust you in a way that makes you just feel like you're ready to take anything. Use that in order to articulate your emotional distress claim.
Sounds like wonderful advice. And if I can take this opportunity to congratulate you, the the vibe going around the firm, everybody's very excited about your mediation yesterday. And I know we have to protect our clients and their confidentiality, which is certainly our priority. But, it's one thing to talk about a theoretical imaginary case, and it's a little bit different to tell somebody a real story of success that you've recently as yesterday, had. Can you enlighten us about that story while protecting your client, of course?
Sure. So we had a very successful resolution at mediation the other day on a long-term care case that involved a woman who there was no dispute whatsoever about whether she qualified for benefits under her long-term care policy. So typically policies require that you need assistance with 2 or more activities of daily living. And there was no dispute that she needed help. She had been in an assisted living facility, and the insurance company was not paying her claim. And her husband luckily had a little bit of assets to afford her care in a memory care unit at an assisted living facility. But like most people, we put aside what we can for retirement, and it goes fast when you are in an assisted living facility and the costs are fairly high. And, he was able to afford to keep her there. But the real problem was they had paid for long-term care insurance, which should have covered her for her care from day one. And instead, they went through an immensely horrible process. And it took years. It took a couple years of trying to get through to the insurance company before they found us. And, it was fairly obvious to us that the insurance company had no defense. There was absolutely no reason that they were justified in not paying the claim for a woman who clearly qualified for benefits under the policy. Those are the cases that we love to resolve for our clients. She desperately needed the care, and we got an outstanding result that not only will her back benefits be paid, but she will be able to pay for all of her future care, and her husband will have enough money to pay for any care that he might need in the future too. A lot of people are concerned when they go to seek out a lawyer, like, will I be able to afford paying for the lawyer when I'm already paying for my wife to be in the care? Like, I'm going to run out of money. And that is one of the reasons that we operate off a contingency fee basis. So you don't pay us an hourly rate to handle your claim. We don't get paid unless you get paid. And that's a way to relieve the client of that additional stress of the financial aspect of it. So, yeah, I can't go into too many specifics about that particular case, but it was certainly slam dunk from our perspective. I felt very strongly about the case, and we were able to get a magnificent result for the client the other day. So, really happy with it.
I imagine so. It's always excellent to hear, a positive result for one of our clients. So, in that mediation room, we're finally there, and my attorney is encouraging me to take a settlement that I'm not exactly sure is satisfactory to me. What do I do from there?
Well, you tell your attorney that you're not totally satisfied with it and see if they can get you a little bit more money. And sometimes they can, sometimes they can't. Sometimes the insurance company comes with a certain amount of authority, and maybe you won't resolve your case that day. So if you are hell-bent on getting a certain recovery and the insurance company comes back to you at the mediation and said, this is it, this is all you're getting today, this is our full authority, then you could say, okay, go pound sand, or you can take it. It's really up to you. So I think your attorney's advice is valuable. They know a lot about your claim, and they are analyzing it from a perspective that perhaps a client just doesn't even have the tools in their shed to analyze it that way. And I would strongly encourage you to seriously consider your attorney's advice. If they're telling you you should take this is a good deal, you should really consider it. But ultimately, you're the plaintiff in the case, and it is your case. And you do have the power of deciding whether you want to take that settlement offer or whether it doesn't sit with you well. So the other thing about mediation is, just because you don't settle that day at mediation doesn't mean that it doesn't settle down the road. I mean, there are a lot of things that the mediator can do after mediation to see if they can get it settled, or sometimes it takes more discovery, more depositions, perhaps a motion for summary judgment in order to get the insurance company to come up with more money to pay you the settlement that you want.
So in that mediation room, at the end of the day, if I've not heard an offer that really is satisfactory to me, and I decide that I want to go to trial, what does that look like? What am I committing to?
So we will start preparing your case for trial. And, if you have a great case, we absolutely encourage going to trial. Obviously, there are huge risk factors for both parties in going to trial. It's a lot of preparation, but generally speaking, there's a bigger risk on the insurance company. I think most people sitting in a jury box are more sympathetic to regular people who have valid claims that aren't getting paid. So yes, there are costs, and we are always assessing those costs when we're advising you about settlement. So the costs of going to trial have gotten expensive. There's depositions. If you need experts, there's fees. If you want to file a motion for summary judgment before you go to trial, there's fees for that. And then there's trial costs. But there is a potential upside that you get a jury verdict that has extra contractual damages and punitive damages that may be above and beyond what you'd ever see at a settlement. So it's not something that we're scared to do, but we do assess the risk. And that's why we advise you. If something is a great settlement and you're taking into consideration certain risk factors, like say you have some bad evidence that's not helpful in your case, we would certainly advise you about that too. But if we think that you have a wonderful case, the insurance company is not coming up with settlement money that they should be coming up with, if they're not considering how big of a risk it is to them, then we'll just proceed and go to trial.